Welcome to the Supreme Court of the United Kingdom, where today we're hearing an appeal in the case of Gourlay and the Parole Board. We're hearing the appeal remotely because of the current pandemic. I'm hearing this appeal with four of my colleagues, whom I will introduce now. First, Lord Hodge.
Good morning.
Lord Lloyd-Jones.
Morning.
Lady Arden.
Good morning.
And Lord Leggett.
Good morning.
The case is concerned with the question whether an award of costs ought to be made against the Parole Board in a situation where one of its decisions has been successfully challenged in court. Further details of the case can be found on our website by following the link from cases to current cases and clicking on current cases. The parties are represented, the appellant by Hugh Southey, Queen's Counsel, and Nick Armstrong, and the respondent Parole Board by Ben Collins, Queen's Counsel, and Robert Moretto. I'll now invite Mr. Southey to begin his submissions.
Thank you, my lord. Obviously, as my lord has already indicated, I appear with Mr. Armstrong and Mr. Collins, Queen's Counsel, and Mr. Moretto appear for the Parole Board. There is perhaps one little piece of paperwork I ought to check. Yesterday, there was a supplementary bundle of authorities sent to the court. I'm afraid that this morning there was one further authority that was identified. I hope my lords and my lady have received those.
Yes, we received the supplementary bundle yesterday and Stankiewicz earlier this morning.
Yes.
I should tell you we are operating entirely electronically, and the supplementary bundle has a separate numbering for us from pages 1 to 320, and equally the Stankiewicz case is numbered separately from 1 to 14.
Thank you, my lord. I will make brief reference to the Stankiewicz case and slightly more reference to the supplementary authorities. But there are essentially three things that I'd like to address the court about today. Firstly, very briefly, just a few matters in terms of the factual background. The factual background is obviously pretty simple and pretty straightforward, but there are one or two things that I perhaps ought to highlight. Secondly, and this will take, I suspect, most of the morning, I then want to go on to the issue of principle, which is whether or not the Davis approach, essentially the first issue of principle rather, which is whether or not the Davis approach should continue to be applied generally in England and Wales. And then secondly, and this will, I suspect, I'll only get on to late this morning and we'll carry on a little into the afternoon. If Davis generally applies, the second question and second issue of principle essentially is, should it apply to the Parole Board, given the features of Parole Board decision making, essentially, and particularly the features of the decision making involved in this case. So, my lord, turning to the factual background, obviously this judicial review arises from a decision of the Parole Board taken on the 10th of March 2014, and that is in the core bundle. It's electronic page 186. And the critical point, two critical points I'd make about that factual background, or two important points I'd make about that decision rather. Firstly, that decision, although technically considering both release and whether there should be a recommendation to open conditions, was essentially focused on the issue of open conditions, because the representative of the prisoner made it clear that he was only seeking open conditions. And one sees that in the second paragraph. And that's important because it means liberty was never an issue in this case. The second point is, is that the Secretary of State, as we understand is common, filed no submissions and was not represented. And that's important for several reasons. Firstly, in our submission, it means in terms of the judicial review, the ability of the Secretary of State essentially to assist the court as to what happened is inevitably going to be limited. The Secretary of State is probably in no better position than the court in terms of what information the Secretary of State has. Secondly, it's also important to recognise that there is, and I'll come back to this, there is probably one very good reason why the Secretary of State was not actively involved in this, and that is that ultimately the role of the Secretary of State, we will argue, has to take account of the fact that in recommendation cases, ultimately the Secretary of State has to look at the parole board decision and independently essentially reach a conclusion as to whether any recommendation should be acted upon. And it's very difficult for the Secretary of State to effectively wear two hats, make representations essentially opposing transfer to open conditions, and then step back and say, having considered having received a recommendation, I'm going to decide whether or not to act on it. There is it does undermine potentially the Secretary of State's independence essentially if the Secretary of State has actively advocated a position. I'll come back. There is some case law on that. Now, that parole board decision obviously was challenged before Mr. Justice King at page, and his judgment is at page 172 of the court bundle, just before the parole board decision. And again, the decision or the judgment records, consistent with what happened before the parole board, that all that was in issue before him was transfer to open conditions. And paragraph 1 of the judgment records that was all the argument was about, and paragraph 41 is where he notes there would be no basis for a challenge to release. And essentially the challenge succeeded on conventional public law grounds. That's at paragraph 31. Essentially Mr. Justice King concluded that the parole board had erred by focusing on the denial essentially as being the sole relevant factor. And so one can put that in public law terms as being a failure to take account of other relevant factors. One final point I should make about that judgment is that the Secretary of State was not an interested party, and there is obviously no suggestion in the judgment of Mr. Justice King that he thought that was inappropriate or unhelpful, and perhaps that's not surprising, as I say, given the role the Secretary of State had played before the parole board. That was then followed by representations about costs, and the judgment on costs is at page 183. And essentially at page 185, paragraphs 10 and 11, Mr. Justice King rejects an argument essentially that there was any distinction essentially between the role the parole board was playing in this context when it was considering a recommendation and the role it applies where release is in issue. And that as a result, it was acting, to use his language in the last sentence of paragraph 10, it was acting in a quasi-judicial capacity. And in those circumstances, it was appropriate to apply Davis. And because the parole board was not an active party, there was nothing improper in it remaining neutral.
Mr. Savvy, this might be an appropriate moment to raise a point with you.
Yes.
Which, I'm sorry to say, it would have been better for us to have raised with you earlier, but it's only occurred to us in preparation for this hearing.
Yes.
And I don't want to take you by surprise. So if it's a matter, if you want later today an adjournment to consider the point, or if you feel you can best deal with it in written submissions after the hearing,
Yes.
we'll entirely understand. I think I could summarize the point in this way. If you look at paragraph 11 of Justice King's judgment on costs,
Yes.
he says that he considers that he should approach the question of costs in accordance with the established practice of the court in Davis.
Yes.
Now, when the case got to the Court of Appeal, the Court of Appeal treated Davis as an authority which was binding upon it.
Yes.
And the case was then appealed to this court so that it could reconsider the what had been said by Lord Justice Brooke in Davies. Now, if the judge is right in describing Davis as an authority on practice, and if Davis therefore is properly regarded as as a court of appeal giving guidance on practice rather than as laying down a rule of law, then one might question whether the Court of Appeal in the present proceedings was correct to regard itself as bound by Davies. And one might also question whether it's really appropriate for the Supreme Court to be laying down guidance on matters of practice for the courts of England and Wales, or indeed the other jurisdictions that we serve. So that's the point that has occurred to us, and it will need to be addressed at some point. But I appreciate both for you and Mr. Collins, more acutely for you, it's put to you cold like this. So we will accommodate. You might want to take time to think about it when we have an adjournment, but we will accommodate any reasonable request you have.
Thank you, my lord. I will take advantage of the opportunity to discuss it during the short adjournment at the very least, and come back at that point, my lord.
Very well. Thank you.
Thank you. My lord, on the assumption as a result that Davis is an appropriate topic for the Supreme Court, can I then turn to the issue of Davis? And the starting point in our submission in relation to that has to be in the context of England and Wales, and it's one of the reasons why we in some senses haven't spent any time on the other jurisdictions.
No, I'm not suggesting that you should.
No. But that was a separate. That wasn't a response to the question just raised. It was just explaining in some senses why I think we would certainly argue, even if Davis, working from the premise that Davis is appropriate for this court, we would submit that this is very much an England and Wales focused appeal, because the starting point in our submission is the CPR, and that was the point I was going to make, was that obviously in England, to state the blindingly obvious, the CPR was the product of the Wolf Review. The Wolf Review was a very careful review and a very detailed review of the civil justice system, and it was clearly intended essentially to result in a set of rules that were both foreseeable and certain. and that's why the CPR is so important in our submission in an English context. And obviously, the rule perhaps obviously the reason why we say this is the starting point is that CPR 44 makes it clear, or that the loser pays rule, as it's sometimes called, should be applied. The current version of the rule, the core volume includes the version that was initially enacted following the Wolf Review. The current version is in the supplementary authorities, so it may be better to use the current version, but there is in fact, other than a numbering difference, as far as I can see, no material difference. And the current version is in the supplementary authorities, and I apologise, we didn't provide this in the initial papers. The current version is at page 144 of the supplementary authorities. And that makes it clear, firstly, that, and this is 44.21, the court has a discretion, essentially, as to whether to make a costs order and the amount of the costs and when they are to be paid. But then, importantly, at sub-rule 2, it makes it clear that the general rule is that the unsuccessful party pays the successful party's costs. Now, it's described as a general rule, and it's clear, it's expressly said that the court may make another order. But in relation to that, the court makes 2 points, essentially. Firstly, or the rules rather make 2 points. Firstly, it does expressly exclude certain proceedings. None of those exclusions are relevant here. And secondly, it identifies factors that are the courts to have regard to that are relevant, essentially, as to whether or not to disapply the general rule. And again, the fact that the defendant in proceedings is a court is not identified as a factor. But in our submission, as I say, 44.2 is an important starting point because it demonstrates that the Wolf regarded the loser pays rule as being something that should be effectively incorporated into the code that is the CPR. And we will submit in a moment. There's good reasons for that. Now, that obviously needs to be read, as do any rules in the CPR, with the overriding objective. The current version of that, which has changed slightly, but probably not materially, is at page 18 of the supplementary authorities. It requires the court essentially to have regard to the overriding of objective of dealing with case justly. We submit that's an important starting point when looking at 44 and the loser pays rule, in part because obviously justice may require a person to be able to access legal advice. And if legal advice is accessed, then the fees have to be paid. And that's why, and I'll come on to this, costs are recognised as being so important as an aspect to access to justice. And then it identifies a number of factors that are meant to be, that are said to be relevant, essentially, to dealing with the case justly and proportionately. The first of which is that the parties should be on equal footing. That, in our submission, supports the recovery of costs, particularly in cases where the respondent essentially is a state body, such as a court, parole board, because the reality is, of course, the state has greater resources. And that was recognised in our submission by Sir Rupert Jackson in his report, and I'll come back to that. He noted essentially the potential inequality of resources in this context. Secondly, it identifies saving expenses and dealing with the case in ways that are expeditiously as being important objectives. And the reason I draw attention to those provisions is that clearly what they both imply is that there is an advantage in early settlement. And that's one of the reasons in our submission why the loser pays rule is important. The loser pays rule essentially it incentivizes a party to settle early if they think they are likely to lose. And in this context, the parole board litigation strategy recognizes the potential to settle early. So what we submit Rule 1 does is it demonstrates essentially the importance potentially, or it emphasizes potentially the importance of the loser pays rule, because Rule 1 being like the key rule sets out sets of principles which we submit are served by applying the loser pays rule. Now, the loser pays rule is, as I say, obviously now is now incorporated into the CPR, but it's important to recognise, firstly, it has ancient origins. I mean, there's material in the papers, I won't go to it. There's an article in Civil Justice Quarterly, it's Authorities 6, tab 81, page 2098, that suggests it goes back to Roman law. It is also applied widely in Europe. That one sees in the papers in another Civil Justice Quarterly review article by Christopher Hodges, which we'll come to for other reasons, which is Authority 6, tab 78, page 2047. And the reason I draw attention to this is that when Lord Wolfe conducted his review and adopted essentially, or put in, or gave court, or adopted essentially a position that led to Part 44, he did so in circumstances where he would have been aware that the loser pays rule was a deeply entrenched aspect of civil justice. He would have had plenty of evidence as to how it works. And in our submission, his endorsement of it obviously needs to carry quite a lot of weight, essentially, or his adoption of it needs to carry a lot of weight. And that means one should be very cautious, essentially, about not applying it in any context.
But it is only a general rule, isn't it? It's only a general rule. I mean, have we looked at matters like judicial immunity when it comes to making an order for costs against a tribunal or magistrates? Would they not be entitled to some immunity?
Well, in terms of it being a general rule, yes, I accept it's a general rule, but it has. I mean, it has become, we would say, in England and Wales, pretty rigid in the sense that there are a few exceptions to it. For example, where a court actively participates in proceedings, but subject to those exceptions, it doesn't seem to be departed from. There aren't, that we're aware of, recent examples of it being departed from.
It's part of a mosaic of issues about costs of civil justice. It is generally thought that that should be a general rule, but there are huge issues around costs and, for instance, as to the amount of the cost and which should be a collectible and so on.
Sorry, I absolutely accept that there are other issues in relation to costs. I mean, cost is obviously a very complex subject, which is why Sir Rupert Jackson needed to conduct such a comprehensive review, and obviously there are still debates about the extent to which his recommendations should be adopted, and they haven't, he would say, been fully adopted. So I accept there are all those issues floating around, but going back to the second aspect of my lady's question, judicial immunity, I'll come on to that. But the critical point we would submit is that while clearly there is some suggestion, certainly in Davis, that concerns about judicial immunity and personal liability may have been part of the origin of this. The reality is that, of course, nowadays, in many contexts, one either has provisions that indemnify judicial decision makers, and as I understand it, that would be the position in relation to magistrates and district judges, or one has provisions that essentially establish bodies that are subject to Davis as having their own legal identity. So in the context of the parole board has a separate legal identity. It is the party, and the cost would be awarded against the parole board, not against the individual members. And the Court of Appeal very recently has made the point that judicial immunity is generally concerned with personal liability, not liability of some other body for the court's decision.
Mr. Southey, sorry, can I just ask you, I don't see this case at the moment as being about when you do or don't apply the loser pays rule in the sense of whether there's an exception to it, but more about what the your argument about what the boundary of the rule is.
Right.
Because if you're a court and your decision gets overturned, it may feel like you're the loser, but that's not how it's conceived, is it? You're not a losing party, even if you're strictly a party to the proceedings. Well, if your decision turns out to be wrong, so it just doesn't apply to a court.
Well, my lord, can I? Two things I'd say about that. Firstly, although, and I fell into one of the traps I'm sort of thought I was going to avoid last night, but I did fall into it, which is I use the shorthand of loser pays because it's an easy shorthand. But if one looks at the CPR, it talks about the unsuccessful party paying the successful party. And that means one can equally describe it as a winner gets paid rule in one sense. And that's how we would submit it needs to be interpreted, partly because of the access to justice issues that arise, essentially, if a winner can't recover their costs. So that's the
but it's a two-party rule. The winner's getting them from the loser, and it doesn't matter whether you call them the loser or the unsuccessful party. It still connotes that they have an interest in the result and that they've lost.
But the second point, but the reason I make that point is that ultimately it may be, although we would submit that this is unnecessary partly for the second reason I'm about to go into, it may be that in reality one has to focus on, because of the access to justice issues, one has to focus on the position of the winner and the need for the winner to recover their costs, essentially, rather than on the position of the loser. And that's the point I was trying to make, is that if my lord is correct, and I wouldn't necessarily accept it, and this is the second point I'm going to come on to, that in reality one has a situation where one has a neutral party on the one hand and a successful party on the other hand, one has to make a decision then as to whose interests essentially are paramount, whether it's the winner or the loser, or the neutral party. Sorry, and we would submit that access to justice means that it should be the winner essentially that is paramount. But the second point I'd make, my lord, is this: one of the other features I've already sort of touched on, and I'll come back to, of modern civil justice is that parties are expected to engage early with litigation and whether or not they wish to fight it. And so to use the parole board as an example, the parole board litigation strategy recognises that once it receives a pre-action letter, it should engage with that. And indeed it should, if it thinks it's appropriate, concede the judicial review. And because of that, in our submission, it's not correct to look at a court, for example, as just being a neutral party, because the court has the option to say, we accept, and the parole board recognise this, as I say, in its litigation strategy, we accept we made an error here, we're willing to consent to the quashing of this, and that saves cost. And that is, as I say, one of the reasons why the loser pays rule applies in our submission. It is to incentivise that sort of behaviour. And the reality is, even if court doesn't file anything, by not consenting, it is putting the claimant to the expense of then having to litigate. the judicial review.
It's of a judicial body.
Sorry, my lord, you cut out there, and so I didn't hear.
If it is a judicial bodies don't operate on the basis that if they think the appeal looks rather strong, then they have a second view of it, decide to concede.
Well, my lord, that may, as you say, may link into the second aspect of this case. But I mean, the parole board litigation strategy accepts that it should look early on at whether or not to concede the case. It doesn't say what test it applies deciding whether or not to concede the case, but it accepts it should look at that. And I mean, one can see. That's not necessarily inconsistent with judicial practice. To use a different example, if one wants to appeal from the first tier tribunal, the first thing one does is one puts in a notice of appeal to the first tier tribunal, and the first tier tribunal can effectively agree to review its own decision, essentially. And so it's not that sort of decision making where a court decides when challenged, is this something that we're going to stand by, is not that unusual.
Thanks.
Lord, sorry, can I just add one other thing to the which perhaps is of importance to the question? Two other things which perhaps are of importance in terms of the question my lord asked. Firstly, one other factor that needs to be taken into account in our submission, and I'll come back to this, is that where you have a body like the parole board, but not just the parole board, this is certainly true of coroners, we would submit has been recognised in the case law in relation to coroners. It would probably apply to specialist tribunals. There is a public interest in the specialist body essentially sharing its specialist knowledge with the court by participating. And that means in our submission, it should be encouraged to participate, but the current rule discourages that. But of course, if it participates, it's very difficult to see that it isn't, in one sense, taking a position, because, and this was a point made by Lord Justice Simon Brown in the Touche case, because of course, as soon as it files something on the law, it is either agreeing with the claimant's version of the law or disagreeing with the claimant's version of the law. However it's phrased, it is taking a position which is either going to assist the claimant or not. And so,
not necessarily so. I mean, we've recently had an appeal where the public body put in the arguments both ways.
Well, but my lady, if the court is, if what the court is looking for from a specialist, if what the review court is looking for from a specialist tribunal is some indication of what that tribunal thinks the law is, then it's going to be expressing a view, and that is the potential value.
Yes, but it's neutrality that one needs, and so it may be expressing the arguments both ways, but it's not taking a partisan view. If they're liable to be subjected to an order for costs, it might be said that that would incentivize them to not to be neutral, but to become partisan in a dispute, which would not assist the court.
Well, my lady, certainly I would submit, which is what has been recognised at Court of Appeal level, is that the assistance the court potentially gets is an independent body coming to the court and saying, based on our experience, essentially, we would see the law as potentially being this. That can be of value. And obviously, it's been recognised by this court, Baroness Hale in AH Sudan, that specialist bodies do have a particular sort of understanding and a particularly good understanding of the law that they're being required to apply. And so one can see value in circumstances where a claimant comes along, in the parole board potentially coming along and saying, well, we know look at this authority, look at that authority, that the point that the claimant is making is wrong, because that's not how we understand the law. That, I would submit, doesn't undermine its neutrality, because it is trying to it's trying to do what it does when it decides a case, which is present the law in an unbiased way. But it is trying to still providing assistance to the court. Well, the other point I was going to make, I said there were two further points that I wanted to make in response to my Lord Legate's question, and that is this. One of the reasons why we submit that the focus should be on the position of the winner is because of the access to justice points that we've made, which are that both the legal aid system and CFAs require effectively the recovery of costs if they're going to be workable. And if one adopts a position essentially where costs are not recoverable from courts in a wide range of circumstances, that potentially limits access to justice in quite important areas. Inquests, obviously these principles are generally applied to coroners. Parole board practice, it becomes attractive potentially for solicitors to take on those sorts of cases, and I come back to that, but that clearly has been recognised as being an appropriate factor for the court to consider. And my Lord, I think, is aware of that, having been involved in the ZN case. So, my Lord, I hope that's probably comprehensively answered the question. Whether it's right or wrong, we'll come to see.
Do we have any idea what the costs to the parole board are of meeting judicial reviews annually?
I have no idea. I'm
how
probably
many
not the person.
There are? Actually, I mean, just be useful to have some idea of the scale of the problem.
Yes, I suspect my learned friend Mr. Collins is in a better position to answer. Yes, to answer that question. Yes. Can I then turn? I sort of obviously been emphasising the importance of the loser pays rule within the CPR, but can I just identify what we would submit are 4 reasons for that rule? And the reason I identify these reasons is that in my submission they apply equally importantly when there are challenges to courts, as they apply in other contexts effectively. Now, the article I referred to a moment ago by Mr. Hodges, that identifies 3 reasons essentially. The reference, I don't think I need to go to it, is Authorities 6, tab 78, page 2047. And the 3 reasons he identifies essentially are fairness. Instinctively, it would seem wrong that someone who has been required essentially to incur legal costs through having to commence litigation is then unable to recover them. Secondly, the loser pays rules deters unnecessary litigation. And thirdly, it promotes proportionality during litigation. And we would add to those 3 that Mr. Hodges identifies one other objective, which is it furthers access to justice. And it furthers access to justice by ensuring that there is a functioning legal aid system, and that there is also a functioning private system that can rely on matters such as CFAs. Turning to the first of the points, and just to make a few points really to sort of bolster those arguments, that those are appropriate justifications and important justifications. We do submit, in relation to the first of the justifications, the unfairness, that the European Court of Human Rights, as well as domestic courts, and I'll come on to some of the domestic courts that have made this point, but the European Court of Human Rights has recognised essentially that there is an inherent unfairness in someone being put to expense essentially to enforce their rights. And obviously the ECHR is potentially relevant in this context because if one thinks about the courts that are affected, or the bodies that are potentially affected by Davis, they include coroners, where Article 2 is in play. They include, although not this case, the parole board when the parole board is dealing with liberty. And so one can see that effectively the sorts of proceedings that are subject to judicial review are ones that potentially determine the rights of an individual. And in our submission, the European Court has at least twice expressed concern, essentially, about people being out of pocket if they have to, if they're forced, essentially, to go to court to enforce their rights. And the two authorities that we draw attention to in that context are, firstly, Scordino, which is at volume 6, tab 70, page 1904 is the relevant passage. And the context of this, just to put it in context, was this was a case that was considering systemic failures to comply with the right under Article 6 to be heard within a reasonable time frame. And the court had accepted that although in an ideal world, one, when faced with such complaints, would expedite the underlying proceedings, one way in which the state could respond essentially to such complaints was to pay compensation. And Para 201, I'll leave the court to read really the first 3 sentences of Para 201. Para 201 in my submission is essentially the court saying that you shouldn't face an excessive burden if one needs to go to court to enforce one's rights. Now that has subsequently been followed essentially by the recent case of Tarhan, which is at tab 71, which is perhaps more closely on point in some senses, because what had happened in Tarhan was essentially that there had been a claim made for damages for compensation for expropriation of land, and the cost order was made that ultimately essentially required each party to pay the other side's costs. So although it's described at times as being a cost order in favour of the other side, in reality, it was an order that each side bear their own costs, a point the European Court picked up. And the court again, Para 78, sort of picked up on the fact that this was not the same as private law proceedings. And it's about a third of the way down the page in Para 78. It's 8 lines in, I think it is, or 9 lines in, where it starts.
Mr. Southey, could you please give us the MS number?
Sorry, my lord, I always forget that. It's page 1932, and I apologise. I will probably do that again, but it won't be intentional.
Well, we only have MS numbers.
Yes, no, I understand.
We don't have paper copies.
Yes, so no, my lord, I apologise. Para 78 is where the court talks about there being a distinction from private law cases, and it being paradoxical again for the state to take away what had been awarded. And then para 86, the court notes essentially that this was essentially a case where each side had to bear their own fees. But it said that such a situation was incompatible with the right to peaceful enjoyment of property. And importantly, and this is the point I really pick up on, it finds that objectionable. The first reason it finds that objectionable, about 8 lines into or 6 lines into para 86, is because the litigation was caused by an act of the state, and the applicant wasn't responsible for it. So ultimately, what the court is saying in my submission is that it's unacceptable, essentially, in circumstances where the individual is seeking to enforce their rights because they've been put in that position by the state, for them to ultimately have to pay to do that. That, in my submission, is important because it's consistent with the basic point I made, which is that it is inherently objectionable, which is the first reason for the loser pays rule, for an individual who has been subjected to an error of law to have to pay to enforce their right to have that corrected, which is what essentially is happening if an individual has to pay for a judicial review. The individual isn't responsible for the error of law in most cases, certainly in most cases. They have a right to have that error of law corrected, but if they can't recover their costs, they're going to be put to an expense. And although these cases were decided in quite different contexts, and I accept we're not in a situation here because of legal aid where one can complain about human rights violation, what they demonstrate is that the Davis rule will cause problems, it will cause unfairness, because it will potentially prevent people recovering costs, including in circumstances where they've been seeking to enforce their rights. I should say the parole board, just as an aside, and I don't think it really, don't want to go down too much of a side alley in relation to this. The parole board cite 2 admissibility decisions to say there is nothing inherently wrong or nothing inherently contrary to Article 6 in the courts sometimes refusing to award costs. We don't disagree that there will be circumstances where there's no violation of Article 6 because costs aren't awarded. The point we're making is a slightly different one. As I say, in particular, we're focusing on the situation where you are trying to enforce your rights, and we're making the point essentially that it is inherently objectionable that you should be put to expense to enforce those rights. But in any event, just as an aside, this is the reason why we provided Stankovic this morning. Stankovic is just an interesting example. I won't take the court to it for any length. It's paragraphs 68 to 76, which I think will be within it. Pages 13 and 14, I think, assuming my lords have got the same.
Yes, it starts at page 68 is at page 12.
Yes, thank you, my lord. What that demonstrates again is that putting someone to expense can of litigating in circumstances where representation is required can amount to a violation of Article 6, perhaps unsurprisingly. All of that in our submission demonstrates the importance potentially of Davis being varied essentially to enable someone to recover costs if there is nobody else who they can recover costs against. So the first point we make is, as recognised by the European Court, is that there is an inherent unfairness in putting someone to expense to enforce their rights. The second point is that what the cost rule does is it it encourages responsible behaviour in the course of litigation. And we've drawn attention to Part 36 of the CPR. Again, I think because of time, I won't take the court to it. The reference is the supplementary authorities. Current version is the supplementary authorities, tab 84, page 37. And Part 36 is obviously an important part of the CPR because it's there to encourage early settlement by effectively penalising people who don't agree to a sensible offer. And what it does, obviously, is, as I'm sure everyone will be aware, is it allows someone to claim indemnity costs if an offer isn't accepted and is then beaten, and is then not beaten, rather. What that requires, though, again, is the potential to award costs. And what's very unclear in our submission is how Davis would apply. But if you can get costs, and we would submit you have to be able to get costs if there'd been a Part 36 offer, then that suggests one should be able to get costs in any event. If there's nothing objectionable in costs following a Part 36 offer, why should there be anything objectionable in costs at the end of a normal claim? And what Part 36 demonstrates in our submission most fundamentally is that the scheme of the CPR, part of the scheme of the CPR is to use costs essentially as a way of encouraging reasonable behaviour. Now, Part 36 operates generally during the course of litigation. Reasonable behaviour is not just important during the course of litigation, it's important before litigation. And the Court of Appeal in the case of M, which has been referenced to in various Court of Appeal decisions considering Davis, deals with this. M is at volume 4 of the authorities, tab 51, memory stick page 1475. And it was the authority.
Sorry, I'm sorry, Mr. Sully. Could you give me the page number again?
Sorry, 1475.
In which bundle?
Volume 4.
Oh yes, yes. Yes. This is M and Croydon Council.
M and Croydon Council. Sorry, I should have given its full name.
Yeah.
Yes.
Thank you.
M and Croydon Council was dealing with an issue that had sort of essentially arisen, which was whether or not there was a difference of approach in costs in public law proceedings to the approach that applied in private law proceedings. And the approach of the Court of Appeal, Lord Neuberger, then Master of the Rolls, was to say that public law proceedings essentially are important and an individual is just as entitled to their costs. And one sees that, in fact, going back a page, para 52 by letter G, starting with the words, a successful claimant who has brought such a claim. Now, the reason I'm drawing attention to it in this context, looking at why costs are important as a way of incentivizing good behavior or responsible behavior during litigation, is that Lord Neuberger went on, having set out that basic principle, which is consistent with the point I just made about fairness, went on to consider essentially why whether or not there were any particular objections to the normal costs rules applying in public law. And he looked at the objections that essentially had been raised, and certainly in two of those, he made the point that the answer to the objection essentially was that if a public body wanted to avoid costs, it should do so early by responding to pre-action letters. And one sees that at the end of para 53, dealing with an objection essentially that a relaxed approach to costs in public law would encourage settlement. para 53, end para 53, his answer, Lord Neuberger's answer to that essentially was, if you want to settle, the time to do that is early, because that's what the pre-action protocol provides for. And then para 55, he noted essentially that sometimes it's said that public authorities give up a claim essentially because it's not worth fighting. And again, he makes the point, the answer to that is, if you want to give up the claim, you do that early, essentially during the pre-action protocol. And so costs have that additional incentive of not just encouraging reasonable behaviour during litigation, they quite often avoid litigation. And as I say, that's reflected in the litigation strategy. I'll come to that. That talks about the parole board potentially conceding in response to a letter before a pre-action letter, which in our submission is a desirable approach for the parole board to adopt. The problem is, if the parole board doesn't concede, it doesn't even engage with that, there's no penalty. And indeed, my lords and my lady may remember, and it's para 52 of the Court of Appeal judgment, which is at page 164, I won't take the court to it again, that the Court of Appeal accepted in this case, there was no evidence that the litigation strategy had been considered and that the pre-action correspondence had been considered, but that didn't matter. Well, that's the problem with not having a cost regime, is in circumstances where, or not awarding costs potentially when somebody loses, in circumstances where the parole board itself accepts it can engage with pre-action correspondence. If it doesn't, there's no penalty. And so it can put the individual to expense, even in circumstances where it should have settled. But it doesn't lose if it does that. The final point we make about the importance of the loser pays rule is it does facilitate access to the court. Given my Lord Reid is presiding, I'm sure the court is very familiar with Unison and what my Lord said in Unison about the constitutional right of access to the court. Unison, for my Lord's notes and my Lord and my Lady's notes, is at volume 5, tab 61, page 1659. And my lords and my lady will remember that what was said there was that the right of access to the court is a constitutional right, emphasising the importance of that. What perhaps is less well known is that about that judgment is that although a number of the cases that my lord reviewed in that judgment were about barriers to actually commencing proceedings, my lord noted that the principle had been applied in a number of cases where what was an issue was a serious hindrance to justice and the access to the courts. And one sees that, and it may be worth going to that. I thought I could avoid it, but it may be worth going to it. It's at volume 5, as I say, page tab 61. I think the relevant passage starts, as I say, at 1659. But yeah, 1659 is where my lord starts by describing the constitutional right of access to the court. 1663 is, though, where my lord makes the point that cases are not just about barriers to bringing proceedings, but include cases where there's been a serious hindrance. And my lord gives two examples of that. Ex parte Anderson, which was about rules that prevented prisoners obtaining legal advice. So it's about access to legal advice, which we would submit is an issue in this case. An ex parte Leach, which was about prisoner correspondence. So we submit that it is legitimate for us to say that here one is concerned potentially with a hindrance to proceedings, such that the constitutional right of access to the courts is an issue. And that's a point.
Mr. Southey, I think there's a question for you.
Sorry, my lord, I was just looking.
Mr. Southey, I just wanted to put to you that the loser pays rule doesn't necessarily promote access to justice. It all depends on the context. I mean, one of the justifications in the United States that they give for why they don't have a loser pays rule is because it makes it harder to bring a claim. And that's often given here. If you risk having to pay the other side's costs if you lose, that deters people from enforcing their rights. And just one more point on that. It seems to me you don't actually want a loser pays rule in this case, because you don't want a rule where the claimant pays the costs if he loses his appeal or his challenge to the parole board. He may not have any money anyway, but he doesn't get made bankrupt if he challenges the decision unsuccessfully. You want a rule where the claimant doesn't pay the costs if he loses, and if he wins, somebody who isn't the loser pays the costs.
Well, my lord, I think firstly, I would accept that's one of the things Sir Rupert Jackson, in fact, suggested, but I recognise I can't go that far necessarily, and this is not the vehicle to pursue Sir Rupert Jackson's suggestion that one-way costs should be adopted in public law. The problem in my submission is whether or not you could make you could come up with a fundamentally better system. We have the system that we're working with, and as has been recognised, I was going to come on to this. In reality, access to justice in cases like this depends upon essentially an effective legal aid and CFA system. And that means that people are only going to be able to take on these cases if they get a proper rate of remuneration when they win, because they're not going to get a proper rate of remuneration when they lose. So that's why, in my submission, access to justice potentially, my lord, in fact, I was going to get the next passage, the next judgment I was going to go to was what my lord said in ZN. And my lord recognised in ZN, in my submission, that access to justice potentially does depend, in the current system, on recovery of costs. Now, as I say, there may be wider arguments. One may be able to come up with a better system, but Lord Wolf clearly was happy to stick with the current system, and that's the system within which we need to work. And as I say, in a system where one has these cost rules, and one also has a legal aid system that is creaking, and one, as a result, is increasingly dependent on CFAs. All of that depends on recovering costs if you win. And my lord, the passage I was going to take my lord to, of my lord's judgment, if one goes, it's the same. I think you're all using electronic volumes, but it is the same volume, volume 5, tab 68. Page 1839, the electronic version. My lord may remember this case because there was quite a lot of argument essentially about the approach that should be adopted to costs. And I'm going to come back to what it says in particular about the relevance of legal aid in a moment. But my lord made some remarks at paragraph 103, which in my submission are why I can point to access to justice as potentially being an issue in this case. And my lord at paragraph 103 identified there being, unsurprisingly, a public interest in facilitating access to justice, and identified how that potentially influenced the approach to costs. And in particular, I mean, there were 3 ways essentially in my submission that all of this influenced the access to costs. But all of those, one was essentially that one shouldn't be too sort of one should look to essentially analyse who'd won. Secondly, one should not set the bar of success too high, and thirdly, one should be astute not to pile down costs. But all of those points in my submission are points that recognise in the current system, and as I say, there may be better systems, but in the current system, one needs to be cautious about denying an individual cost, because if you deny an individual cost, you are potentially impacting on interest and on access to justice. I mean, those issues about access to justice in my submission have become more acute in recent years because of developments, and there are two developments that we highlight. Firstly, as is well known, there have been cuts to legal aid, and I mean, one can trace them back to the Access to Justice Act in 1999. But just to give two recent examples, the rates for High Court litigation, which would include judicial reviews, have been dramatically reduced. And so I won't take the court to them. The reference is Volume 2, Tab 16, page 665, the Civil Legal Aid Remuneration Amendment Regulations. They provide legal aid rates for solicitors are £71.55 an hour and £67.50 for juniors. And that represents a very significant cut in relation to previous rates, which themselves were cuts. But the difficulties for public lawyers of sustaining a practice are enhanced by the fact, which is, again, I won't take the court to, but it's Volume 2, Tab 17, page 670, the Civil Legal Aid Remuneration Amendment Regulations, which impose limitations on being paid if you don't get permission. And so what one sees there, if one effectively is operating in an area where one is not going to recover costs, if one's going to act in judicial review proceedings either as a junior counsel or as a solicitor, one is only going to get paid a very low rate if one wins, but if one loses, one is potentially going to get paid nothing. And those cuts are relevant because in our submission, consistent with the passage of my Lord's judgment that I've already been to, but other passages that I'm going to take the court to, the court has to be concerned to ensure that there is access to justice. And if I can take the court, it's almost the same to volume 3. Tab 25, page 838. The judgment of this of the Supreme Court is, in fact, I think the first judgment the Supreme Court delivered in JFS, a judgment of Lord Hope, who was dealing, of course, with a more generous legal aid system because it was before the most recent cuts. And can I take the court? It's page 838 of the memory stick, paragraphs 24 and 25. If I can invite the court to read those passages, and I'll what in my submission those passages demonstrate is, and they demonstrate without evidence because that's obvious in our submission, is that the sustainability of legal aid and the sustainability as a result of access to justice depends essentially on costs being recovered because of the impact it has on rates of remuneration in particular. And yes, it is, as my learned friend says, that is obiter, but it's been, we would submit, repeatedly applied, and it's a clear statement of principle, and it's a recognition, and it was, as I say, delivered at a time where legal aid was in fact more generous, and it's a recognition of how denying legal aid lawyers in particular costs has impact for the sustainability of legal aid. Now that was picked up most recently, going back to ZN. I'm sorry to take the court back, but I hope this makes sense, because it sets out sort of chronologically the position. If one goes back to ZN, which is volume 5, tab 68, page 1834, Lord Justice Singh, in fact, delivered the first judgment considering legal aid. And if one goes to 1834, I'd ask the court to read paras 87 and 88. And then also 93. Well, Lord Leggett also dealt with this, arguably in a slightly different way, at paras 100 and 101. And then Sir Brian Levinson, President, adopted both, well, endorsed both judgments, but in particular Lord Justice Singh at para 106. And what in my submission these judgments demonstrate essentially is an increasing awareness, or an awareness on the parts of the court, both JFS and ZN demonstrate this, an awareness on the part of the courts that the sustainability of a system designed to ensure access to justice depends upon the recovery of costs. Because if lawyers who are going to act in these relatively low paid but important areas are not paid inter partes costs when they win, their practices may well become unsustainable, and that will have an impact on access to justice. And that's important because what one sees in my submission, when one compares, for example, the approach in ZN to the approach that's been adopted in Davis cases, if I can describe them in that way, is that in large areas, the courts are recognizing that access to justice is potentially under threat and taking account of that in relation to costs. But in this particular area, where it is a court that is a defendant, that factor doesn't seem to carry any weight. And so one has areas such as inquests, the parole board, where judicial reviews are unlikely to generate, or may well not generate, inter partes costs despite the person being successful. And that will have impact on access to justice. And yet those are areas where there is obviously important rights, such as the right to life, in issue. My Lord, I'm conscious, I think my Lord mentioned it's 11:45 break, and I think I'm, according to the time on my computer, that's exactly 11:45. My Lord, sorry, for some reason I can't hear, my Lord. I don't know whether I'm the only one who's...
Oh, no, I'm sorry, I had switched off my microphone. I hope you can hear me now.
Yeah.
No, if you've reached a convenient moment, then by all means, we'll adjourn for about 5 minutes. Thank you very much. We're ready now to resume the hearing of the appeal in the case of Gourlay and the Parole Board, and I'll invite Mr. Southey, Queen's Counsel, to resume his submissions.
My Lord, can I just deal very briefly, and I'm going to come back to it, with the question my Lord asked me early on about practice. Yes. And can I just for the moment say, can I park that again to lunch, because we're returning then to where I was. The point I was making before we broke essentially was that for legal aid effectively to be an effective access to justice, under the current regime, it requires essentially costs to be recovered, and if one has significant areas of practice where costs will not be recovered or will rarely be recovered, that is going to have an impact on the viability essentially of practices, and that's been recognised, as I say, on a number of occasions by a number of judges. The second feature of the current arrangements that in my submission sort of make it clear that there is a need for costs to be awarded in the Davis type situation is the development in England and Wales of CFAs, conditional fee arrangements, or agreements rather. And that development essentially was intended in part to fill the gap caused, or the problems caused, by legal aid. And if authorities needed for that, one sees the history essentially of the development of legal aid, the CFAs rather, set out in Lord Neuberger's judgment in Lawrence and Fenn Tigers Limited, and that is volume 3, tab 27, page 885, and paragraphs 12 to 14 and 12 to 15 really set out that the way in which CFAs came to be adopted reasonably widely in England and Wales. And in particular, what it makes clear is that, and one sees this in paragraph 14, is that CFAs were intended to expand access to justice, and they were intended to do, and in particular the changes to CFAs in 1998 and 1999, well, in 1999 were intended to facilitate access to justice. And they were intended to do that by making them work potentially in cases which were not just about money. And one of the reasons they were intended to do that is because the 1999 Act, the Access to Justice Act, limited legal aid, essentially. And that's also clearly set out, essentially, in paragraphs 26 to 28 of 26 to 28, particularly, yes, paragraphs 26 to 28 of Lord Neuberger's judgment. Now, the problem in our submission with having an area of law where effectively costs are unlikely to be recoverable, it is that makes, particularly in areas where damages are also unlikely, that makes CFAs highly unlikely to be realistic. It's only if CFAs, if one can recover costs, that CFAs will work. And so by having areas where costs are extremely difficult to recover, one is effectively limiting the ability of the private market to fill the gap caused by limitations on legal aid, despite the fact that it's clearly intended that the private market will fill that gap. And that's another reason in my submission why the Davis approach is potentially harmful to access to justice. It makes it very difficult for the private market effectively to step up and fill the gap. Now, all of that was part of the context, essentially, of the Jackson Review. And the Jackson Review concluded essentially in relation to public law, no suggestion that courts were any different, that, and it goes perhaps to my Lord Legate's point, that effectively the way to balance the inequality of arms that there is in public law is to adopt a system of one-way cost shifting. The reference to that is paragraph 5.11 of the Jackson report, which is at memory stick page 2041, volume 6, tab 77. And he described there, the reason he talked about one-way cost shifting was he described there an asymmetric relationship. Now, I'm not arguing, as I say, for one-way cost shifting. I'm just arguing for the recovery of costs where someone is successful. But that inequality of arms, which he identifies in our submission, is a real problem in this area, because if one thinks about the position of the Parole Board reserves for itself the right to, through its litigation strategy, the right to participate if it wants, but it also reserves the right essentially to protect itself against costs. So if it wants to participate, it can obtain legal advice. It obviously is a public body, it will have access to legal advice. It can engage, but equally it has this ability to protect itself against costs, and that is an asymmetric relationship. The claimant, who may have discovered, may be right that they are the victim of an unlawful decision, they will not be able to prevent the Parole Board participating if they want to, so they may make themselves liable to the other side's costs, but they also may not be able to recover their own costs. If the Parole Board, in contrast, does participate and is successful, it may well be able to recover its costs. So there is, at the moment, an asymmetric relationship. Should be noted, while talking about Sir Rupert Jackson, this recommendation obviously wasn't adopted. Sir Rupert Jackson, in our submission, and I'll come on to this, has certainly never suggested that he's effectively revised his opinion. What he has done is express regret that legal aid has been further cut, and because of the impact that has on access to justice and legal aid lawyers. And I won't take the court to it, but the reference to that is memory stick page 2063. Now, the Parole Board has drawn attention in its written case in the context of Sir Rupert Jackson to his judgment in RL, which is at Authorities 5, tab 57, page 1612, where effectively, well, what we would submit the court concluded essentially was that the claimants in that case couldn't claim to have won. Paragraph 75 is essentially the test that Lord Justice Underhill applied to decide whether or not to award costs, which involved consideration essentially of whether or not there'd been a legal error and whether the proceedings needed to be commenced. And ultimately he concluded, applying that test, para 78, there was that it couldn't be established that the claimants were entitled to their costs. What he then did was note the importance of costs to publicly funded lawyers, consistent with ZN, consistent with JFS, but essentially said you can't get your costs if there isn't a principled basis for it. And that's what Sir Rupert Jackson then endorsed in paragraph 79. And of course, we're not saying that because legal aid is being cut and because of the difficulties faced by legal aid lawyers, you should get costs no matter whether or not you're successful. We are saying that obviously you have to be successful, but all we're seeking to argue is that there shouldn't be essentially a special rule that protects courts and tribunals and applies a different approach to courts and tribunals to that approach applied generally, which is you recover your costs when you win. I mean, ultimately, the basic point we're making is that, and I go back to my Lord Legate's point about whether or not the loser pays rule is a good thing or not in terms of assisting access to justice. We have a system that's based on the loser pays rule. That is what Lord Wolfe decided was important. Within that system, because of factors such as pressures on legal aid, because of the way in which CFAs have been developed to fill that gap, obtaining costs when you're successful is an important part of access to justice. Obviously, the risk of cost if you lose is a deterrent, but that we're not in a position to challenge. There is no reason why it is less important that you recover costs when you're challenging a decision of a court than in other contexts. I mean, if anything, some of the rights in issue, and I've made reference to the fact Article 2 can be an issue, Article 5 can be an issue, suggest it's particularly important that there's effective access to justice. And so there is no, if access to justice requires the recovery of costs generally, there's no reason why there should be a set of cases or a set of defendants who are more favourably treated. Particularly when there's nothing, I mean, what the state could do, essentially, I suppose, would be put in place, for example, increased legal aid when you're judicially reviewing a court, but it hasn't done that. There's nothing to balance that out. And so one has a system which generally depends on the recovery of costs, but a group of defendants who are protected from that. Now, my lord, that is the context of Davis, and I probably ought to go to Davis now. And Davis, just to say one sort of preliminary point, thing about Davis. Davis, and Davis is, by the way, it's Authorities tab 1, page 314. Davis, as has been said in, I think by the Court of Appeal in this case, is clearly a comprehensive review of the development of the approach to costs against judicial and quasi-judicial bodies. it sets out the history of that in great detail. But there are 2 points I'd make about it as sort of preliminary points. Firstly, although it is, as I say, a comprehensive review of the history, it is not, it couldn't be, it's very difficult for any judge to carry out the sort of comprehensive review of the sort of policy considerations that are relevant that Lord Wolfe conducted. This cannot be an equivalent to the Wolfe Review. And I make that point because, as I say, the Wolfe Review clearly, ultimately, whatever the rights and wrongs of it, decided that the loser pays rule should be a key part of the English civil justice system.
That's a point that might be made against your argument, Mr. Southey, that the sort of argument you've been developing is one which it might be said is more apt for consideration by the sort of review that was carried out by Sir Rupert Jackson or Lord Wolfe, rather than by a court deciding a lease inter partes.
Well, my Lord, what I'd say in response to that is that Lord Justice Brooke, in our submission, rightly recognised that some of the developments that I'm describing were potentially relevant to the court's approach. When one looks at the contemporaneous factors he identified, they included some of the factors that I've described, including practice of pressures on public bodies in terms of funding. And in my submission, that is right, ultimately, partly for the reason that both my Lord Leggatt and Lord Justice Singh gave in ZN, which ultimately is this: although public expenditure is generally a matter for the government, access to justice is something for the courts, and the courts have powers, such as powers to award costs, which in my submission are properly exercised in a way that is intended to facilitate access to justice. And that's why, as I say, things like legal aid cuts have been taken into account. What the courts have been scrupulous in doing is not saying essentially this is too low a rate. What they have done, though, is recognise the potential effects and say they have effects on access to justice, and that's where the courts are properly engaged in my submission. And that's why the sorts of factors that I've identified can, in my submission, properly be taken into account.
But the courts cannot assess the effect on the public bodies. We're actually only dealing with judicial bodies, I think, of changing the practice, and that would be relevant to any review such as Lord Reid has just mentioned.
Well, I mean, if one looks at Lord Justice Brooke's judgment, he does to some extent take account of the fact that public bodies are, and in particular judicial bodies, are subject to pressures potentially to recover their costs. And so he takes account of the fact they may actually seek to recover their costs when they participate in litigation. So one can, to some extent, what obviously is perhaps more difficult for the court to do, and I'm not suggesting it should do, is to sort of say, well, this would cost, I don't know, £100,000 or something, and as a result, that is not a sensible sum for the court to sort of require the parole board to pay. That obviously would be difficult. But I come back to my basic point, which is ultimately the court does have to be concerned about access to justice. That is properly within its territory.
For example, in Unison, the court had really an enormous amount of factual evidence, which was not in dispute, about
Yes.
the impact of the increase in fees on proceedings.
Yes. But partly because obviously one has to keep cost proceedings in proportion, I suspect. When one looks at the approach in JFS and ZN, the court has been willing to say it's obvious that if you can't recover commercial rates, there's going to be pressures on practice, and that, in my submission, it must be an acceptable approach, and it's done that without any evidence as to what the actual impact was. It said this is essentially common sense, basically, and that, in my submission, must be right. Can I also just pick up one other point about the review? One way also of looking at this and whether or not this is a sort of permissible exercise is to say, and this is why in I perhaps started with the CPR, is to say that in this area there has been there've been two comprehensive reviews essentially of approach. There's been firstly the Wolf review, and then there was the Jackson review. The Wolf review essentially says, without apparently on the face of it carving out any exceptions that are relevant, the Wolf review says, as part of our civil justice system, we are going to retain and apply the loser pays rule. The Jackson review, not adopted, essentially says, in relation to public law, which is obviously what we're talking about, in fact, one should probably go further and have a one-way cost rule because there's an inequality of arms. Neither of them, on the face of it, suggest there's any different approach required to courts. And they are the starting point in terms of reviews because they are proper policy reviews and provide an evidential basis. One then needs to feed in my submission, the history described by Lord Justice Brooke in his judgment, but one needs to take account of the fact, and this is the second point I was going to come on as a sort of overview point, one needs to take account of the fact that actually the history, although his judgment sets out in great detail the history of the rule he then identifies, the reasoning underlying that rule is much less clearly identified because it's not, presumably because it's not as clearly identified in the cases. We've sought to identify what the reasons were for that rule because that's obviously important, but it's actually quite difficult in our submission to do that because the older cases aren't necessarily, certainly using the summary provided by Lord Justice Brooke, are not necessarily clear essentially about why the approach has been adopted. So I'm going to the judgment just so that one understands the structure because it's helpful. Obviously, the way in which the judgment is structured is that paragraph 3, Lord Justice Brooke sets out 4 issues for consideration, 3 of which were essentially what is the established practice in various areas, and the 4th one, which is essentially what we're asking the court to consider, is whether or not there are contemporaneous reasons for departing for that practice, in particular since the civil procedure rules, recognising in particular in my submission the importance potentially of the civil procedure rules. Now, having said that, unsurprisingly, the judgment then goes through at length, effectively, the historic practice, what the established practice was. And the first factor that seems to have been identified as potentially being relevant, which was at paragraph 6, is that it was identified that there had been an issue for a period of time, essentially, as to whether or not justices, because a lot of these cases were about magistrates, whether or not justices could be personally liable. And that was also an uncertainty in the area of coroners. And that, in my submission, is something that in one sense does seem to be generally a historic problem, certainly in the context of the Parole Board. The Parole Board is a body corporate. Nobody is suggesting that Parole Board members should be personally liable for costs. In many areas, such as inquests and magistrates, there is now a statutory indemnity. In other areas, a judicial body or a judicial type body will have a statutory identity or a legal identity. And so personal liability is less likely to be a factor. And that's important because when it comes to judicial immunity in my submission, as the Court of Appeal recently noted, judicial immunity is generally concerned, we would say is always concerned, in fact, with personal liability, because that's where the individual potentially comes under pressure. The second, having made that comment about the uncertainty as to personal liability, Lord Brooke then reviews a number of judgments in relation to magistrates, starting with judgments of Lord Goddard. I'm not going to take the court through all of those, you'll be pleased to know, but what is notable about that is it's quite difficult to see, although one sees there the development of a practice that magistrates are discouraged essentially from attending. The reasoning for that is perhaps less clearly articulated, and in our submission there are perhaps two reasons identified. One is at the bottom of page 11, and then bottom of paragraph 11 and first line of paragraph 12. Bottom of paragraph 11 includes essentially a quotation from Lord Justice Goddard, Lord Goddard in the course of argument, where Lord Goddard essentially talked about how the tribunal, having appeared, ought to then be liable for costs, essentially. But that is then, it would appear, explained at para 12 by the fact that Lord Chief Justice Goddard was concerned essentially to prevent or to limit justices appearing in his court when they could say everything they needed to say by affidavit. So there seems to be an identification there of the fact that it was regarded as undesirable essentially for magistrates to appear in court. Quite why that should be when they were encouraged to file an affidavit, which would presumably include potential additional reasoning, is a little unclear, particularly when one sees later in the judgment a recognition of the potential value of specialist tribunals. The second possible explanation is at paragraph 19.
It may be helpful just for a moment to just note in paragraph 8 where this history is being introduced, that what Lord Justice Brooke says this is a series of judgments. Lord Goddard explained clearly what was the practice of that court in these matters. He says the judgments which I'll cite reflected the understanding of all three members of the court as to the established practice. So it's clearly a matter of practice that's being illustrated by the judgments that were then cited. Well,
yes, I mean that in one sense is the point I'm making, is that what the history tends to demonstrate is the development of a practice. The reasoning for it is perhaps less clear, and if one's going to look at the contemporaneous arguments against this practice, in one sense one needs to look at what the basis of the practice was. And I'm saying it's quite, in some senses, it's quite difficult to see what the underlying concern was. Certainly there was a concern at one stage about personal liability, but that isn't really a relevant consideration now. There is this apparent concern to check, to use the language of the judgment, check attendance essentially, or but again, in one sense, in many cases, we would say one has to ask why that should be a concern, particularly given the specialist assistance that can be provided. But in any event, it doesn't necessarily change the basic point as to who should be liable for costs. The third probable point that's identified essentially is that which is at para 19, where it makes where Lord Justice Brooke makes the point that one exception to the rule is in relation to flagrant improper behaviour. But he then goes on to say, but generally, because of the fact you are concerned with resolving a lien between the parties and a prosecutor in the magistrates' court, essentially there would be no need for the justices to be represented. Well, the difficulty with that as being a basis for a rule is that, of course, well, among other things, of course, this rule is now applied in circumstances where there won't be a leave. So it applies to coroners. It applies potentially to the parole board where the Secretary of State has actually not taken any position in relation to the litigation.
When you're talking about a rule, and indeed, Lord Justice Brooke, beginning of paragraph 19 refers to ground rules.
Yeah.
We're talking about a rule of practice, not a rule of law.
Well, my lord, I without wanting to preempt the answer to the question, what we would say is this: is that, and in fact, my learned friend, Mr. Collins, in his written submissions, makes this point. Of course, ultimately, costs are generally matters for first instance judges, but they do that applying principles essentially identified by the appellate courts. And what this is doing essentially is identifying a set of principles to apply. I mean, on the current state, on the current state of
it, it's guidance as to how to exercise a discretion.
Yes, but it's legal guidance in the sense that it wouldn't, in our submission, be open to a first instance judge to say, well, I know that Davis says this, but I simply disagree with Davis.
No, you're quite right, but he would always be able to exercise a residual discretion.
He would.
If for one reason or another he thought the case wasn't appropriately dealt with under the general ground rules established in Davis.
Yes, but to use this example, I mean, if the judge was correct that Davis effectively applies, and obviously we would say it should now be revisited, but if the judge was correct that Davis applies and it applies to the parole board, in circumstances like this, the judge, we can't, I mean, it seems to us it would be very difficult for us to identify any reason why the judge should have departed from Davis on the facts of this case, because this was a classic case where the parole board, other than not conceding before the commencement of litigation, as they could have done in response to the pre-action letter, they didn't engage, they didn't do anything. So there's no reason for departing from the Davis approach if Davis applies. I mean, well, that's why. But
can I ask another question? Yeah. If you go on in the judgment to let me see now. If you go on to paragraph, I think it's 51.
Yes.
Which is on page 327.
Yes.
This is really when Lord Justice Brooke is winding up. He says, I don't consider it appropriate to say more than this in the present judgment. It may be that the Rules Committee may consider that further guidance by way of a practice direction is desirable. Now, I think that makes it, I think, pretty clear that what we're talking about is matters which might properly be dealt with in a practice direction, and therefore not matters of law. And I wonder, is this an issue that has actually been? The Rules Committee is an obvious place for the sort of problems. I mean, you're talking about a systemic problem which has resulted from changes to the legal aid scheme in recent years. And one might have thought that that was a matter that could properly be raised before the Rules Committee, which would be able to look at the matter in a rather more rounded way than one can in a particular case.
Well, I think there are three things I'd say in relation to that. Firstly, I have to say, as I've read para 51, what para 51 is dealing with is primarily the problem he identifies in para 49 and para 50, which is that he was concerned that because of the fact he had now effectively changed or given changed guidance in relation to the coroner who had appeared neutrally, what he was doing was essentially incentivizing someone to not appear at all. That was a problem because the court was potentially denied the assistance of the coroner. And so he was concerned there that there might need to be an amicus. And Para 51 was saying, effectively, we may need to look again at how we deal with this particular problem. So he was recognizing effectively that he had caused a problem in relation to his costs approach, and was seeking to address that the particular problem of the court being denied assistance. He wasn't suggesting necessarily that it wasn't acceptable or it wasn't appropriate for him to do what he'd done in Para 47. Yeah.
No, I'm not for one moment suggesting the contrary.
Yeah. But in Para 47, he clearly had taken account of the sorts of factors that I've identified, because he was looking at current practice but my lord, what I would say, secondly, as far as I'm aware, the Rules Committee hasn't looked at this. I mean, it might be desirable to do so, but the fact the Rules Committee hasn't looked at it hasn't prevented, as I say, courts looking at the difficulties with access to justice that are potentially caused by a denial of costs and trying to deal with that. And that's really ultimately what we're seeking to do here. Is we're going to say we're seeking to argue that there's a problem with access to justice as a result of the approach that the Court of Appeal adopted in this case and continues to adopt. And as a result, that's something that's appropriate for the court to address.
Yeah, I see.
It must all depend on the particular circumstances, so Mr. Southey, whether it's suitable for the court to deal with it.
Well, I sort of try to avoid, so I can discuss it with my team, the answer to
yes.
my Lord Reed's question. All I would say is that I mean, we're certainly aware, having done some work on it this morning, that there is precedent for this court dealing with cost issues, and we would submit correctly because of the access to justice issues that are potentially thrown up. And we would say actually this case throws up issues of wider principle than the case I'm thinking of. There was I think about 2014, a local government case where the court dealt with costs.
We do sometimes, but it, at least in my experience, has tended to be in rather special circumstances. There was, for example, quite recently a case about third-party cost orders being made against insurance companies.
Yes.
And we took that case and issued a judgment, which from memory, I think I may even have, I think I probably drafted it, but it was Lord Briggs and I wrote, I remember now. And but the point there was that the jurisdiction to make third-party cost orders had been established by a judgment, a decision of the House of Lords, and a certain construction had been given to what Lord Gough had said in his speech in that case. And so it was appropriate for something which had its origin at our level to be looked at again by us. But if something could ordinarily be dealt with by way of a practice direction in the Court of Appeal, then it would be slightly strange for this court to be performing a function in the form of a judgment.
Well, my Lord, the example I was thinking of was Hunt and North Somerset, which was 2015, where which was obviously a public law case, so it's closer to the circumstances of this case, where certainly, as I'm told by those who are sort of figuratively behind me, that the reason the Court of Appeal, this court took the case, was that the Court of Appeal had identified it as an issue of principle. Now, now here one sees Lord Justice Brooke, and I accept it goes back to Davis, saying there is a principle to be considered here, spending quite a considerable amount of time on identifying what the correct approach was, and in fact adopting a slightly different approach to what he said practice had been in the past, but clearly giving guidance as to that approach, recognizing that approach would have an impact, because that's where he was concerned about the the impact on the potential need for amicuses, and then subsequent courts of appeal saying effectively this is now binding on us.
Yes.
So
yes. Well, in this very case, the Lord Justice Higginbotham says that Mr. Southey, in my view, properly conceded that this court is bound by Davis.
yes.
He accepted that he couldn't argue before this court that Davis was not still good law, and well, it's a matter you have to deal with. I'm not expecting to deal with it now, but we have a concern that Davis may not be law at all, let alone.
Yes, well, I understand the concern, but of course, in fairness to myself, I think by the time, certainly at about the same time, we'd had. I'm going to horribly mispronounce this. I think it's Gourlay, which was first in time, which said we're bound by, and one then has Fariki. So one has a series of recent Court of Appeal judgments, which may reflect, to be frank, the pressures on legal aid lawyers to try and recover their costs, where the Court of Appeal is consistently saying Davis is the approach we've got to adopt, basically. And so that, in our submission, puts us into a very analogous situation with Hunt, because one has effectively the Court of Appeal saying, rightly or wrongly, this is the approach we've got to adopt, effectively. Well, can I go back to Davis? And I think we've taken I'm going to slightly speed up because I'm conscious of time. The critical point we'd make, as I say, is it is difficult to see what the reasoning is, but that what is noted in it, in some senses, is the disadvantages essentially of the rule. In the coroner's cases that are cited, there are a series of cases where judges at first instance and but in the divisional courts, quite often Lord Justices of Appeal have expressed concerns and indeed have allowed these sorts of considerations to influence them. The concerns essentially that you couldn't recover costs, the basic fairness point that I made. One sees that at paragraph 32, Lord Justice Watkins in the Gourlay case, ex parte Driscoll, para 34, which was Lord Justice Kennedy and Mr. Justice Pill as he then was, and then ex parte Johnson at para 35, and all of that then fed into Touche, which again was influenced by that sense of unfairness that you shouldn't be prejudiced by the inability to recover costs. And that sort of concern then was sort of linked in my submission in the judgment with a sort of review of recent developments, and one sees that at para 44 to 45, where a number of factors were identified, which in my submission all tended to point to an increased willingness to order costs essentially against courts. One sees there, for example, the fact that the CPR had introduced the overriding objective, and which is consistent with the points I made about the CPR. The fact that increasingly claimants were having to fund themselves, and the fact that important rights were an issue in this context. And that led essentially to the approach of Lord Justice Brooke, which was to modify the rules so that it was no longer sufficient to be neutral as a way of avoiding a costs order. Essentially, his conclusion was one had to limit oneself to, if one was a coroner, to filing a witness statement if one wanted to avoid costs, and one says that it sees that in para 49. Now, two features of the judgment also I perhaps should pick up. One is that Lord Justice Brooke appeared to regard it as a factor in favour of an award of costs that somebody was not in receipt of legal aid funding. Now, in our submission, that is clearly wrong, because there is a statutory provision which says you shouldn't be worse off effectively if you're in receipt of legal aid. and for good reason, because of the points I've made. I'll come back to that. But the second thing is that clearly Lord Justice Brooke was concerned that that was an undesirable solution for the reason I already identified, which is he recognised that there was value to the court, essentially, of participation from a specialist body. And that's why he was in our submission uncomfortable, as one sees at para 49, with the position he'd reached. Davis in our submission should be read with Touche as well, because Touche was shortly before Davis, and was another consideration of the principles by the Court of Appeal to be applied. It's, as things stand, it's not actually inconsistent with Davis, because ultimately it was concerned with a situation where the coroner had attended, albeit attempting to participate on a neutral basis. But it's significant for two reasons in my submission. Firstly, making good the point I made earlier in response, I think, to a question from my Lady Arden, and it's page 372 of the electronic version. Sorry, I should have said that. Tab 4, core authorities. It makes the point that essentially it is very difficult to apply the distinction between a court appearing essentially as a quasi-amicus and playing a party. Now, that's not to suggest that it didn't also recognise the value of the coroner attending, and it clearly did by letter D on page 373 at the end of paragraph 54. Lord Justice Simon Brown, as he then was, recognised the value essentially of the coroner attending because of their specialist knowledge. But ultimately, in the following sentence, essentially, the concern of the court was it was still pretty unacceptable that if you successfully argued a point of law, you couldn't recover your costs. And as I say, coroners are an important issue in this context because of the fact there is no other party to it. There is no list, so there is no party against whom one can recover costs other than the court. So in my submission, what one gets from Davis and Touche is a rule, apparently, which is that if you, as a court, participate in litigation, one is going to be liable for costs, essentially, if one loses. But if one doesn't participate, there is no liability for costs. The reasons for that rule are not entirely clear, and don't always support it. So I mean, there is, as I say, the concern about personal liability, but that's unlikely in reality in the modern world to be a factor. There is a concern essentially that there may be a list between two parties and the court shouldn't get involved, but that won't always apply. And that needs to be balanced against the fact that it's been recognised that there is a value to specialist participation.
But also, isn't there a concern that judges should not be parties to proceedings and put in affidavits about what happened and so on, and that having a rule that they do not incur liability for cost if they do not appear and participate will dissuade them from appearing?
Well, I don't accept. What I wouldn't accept with respect is that there is such a clear rule that judges shouldn't participate. I mean, if one thinks about going back to Lord Justice Brooke, he was concerned effectively that the cost rule would discourage participation because he could see that it was of value to have the coroner attending. That's why he talked about the potential need for amicuses as an answer to that. But he clearly was concerned. Lord Justice Simon Brown was concerned because he noted the assistance that the court had got from someone attending.
But if the coroner comes along in a confrontational mode, then he prejudices his impartiality, and that may be thought to be undesirable too. It's a competing value that you ensure the judicial independence of the court involved. I'm just trying to try and explore the problem with you. I'm not expressing.
No. I understand. It's helpful. But what I would say in response to that is that if a court, having determined a case, comes along to a judicial review court, or if a judicial figure comes along to a judicial review court and says, essentially, perhaps to use the Parole Board example, we didn't concede this case. We have a policy of looking at whether we will concede a case. We didn't concede this case because our understanding of the law in relation to Parole Board reviews is X, whatever X is. That, in our submission, can't undermine the court's independence. It is expressing a view on the law, having heard the case, which is no difference in many respects to delivering a judgment. Once it does that, of course, it is either assisting or undermining the case of the claimant. And if it undermines the case of the claimant, it is potentially putting the claimant to cost if the claimant is going to successfully challenge that interpretation of the law. But it is there in our submission. There is no question there about independence. It's no. I mean, there isn't. One of the things that in our submission the Parole Board seeks to do is almost say there needs to be a rigid line, essentially, that once a judicial figure has reached a decision, that's it. The judicial figure should step back. But that's, in our submission, there's no reason in principle why that is correct. Judicial decision makers do quite often express views on arguments as to whether or not they're right or wrong. They'll be asked to consider whether or not to grant permission to appeal. In the Parole Board context, they'll be asked that there's an issue potentially about whether or not they concede the case. I'm going to stop there for a moment because I've seen my Lord Leggett's got his hand up. And
I recognise that there may be issues of practice and how you apply principles around the edges of it, but fundamentally, isn't there a principle that if your role is that of a neutral, impartial decision maker, the fact that you make a mistake in your decision is not a reasonable basis for making you pay the costs of one of the parties, because you're not contesting their view, you're just trying to do the best you can, making up your mind what the law is. Now, it might be different if you step into the arena and start defending your decision in a higher court, then you may make yourself liable, but otherwise it's just fundamentally inconsistent with your role to say that you have to pay because a higher court or body decides that you got the law wrong.
Well, Lord, can I firstly, it goes back to the point I made about the origin of Davis. We're not suggesting, obviously, that anyone should be personally liable for costs. And in a modern environment, that would be highly unlikely. I mean, if one thinks about the Parole Board context, the Parole Board is a body corporate. It's not going to be the individual members of a particular panel who are liable for the costs. And that's an important starting point, because I do accept there would be issues if judges were personally liable. The reality is that here, because of the way our system works, you have a right of challenge if a body like the Parole Board gets the law wrong. But it's a right of challenge that quite often will involve you incurring cost. And the question is, who should bear that cost? Should it be you who bears that cost for enforcing your legal rights, or should it be the parole board? And in our submission, there is nothing inconsistent with immunity for it being the parole board. I mean, the parole board itself, the parole board doesn't say, because that would be inconsistent with its litigation strategy. We don't ever participate. We don't ever seek to defend our decisions. It adopts a policy which allows it to, on a discretionary basis, quite what factors it takes account of are unclear. Nobody has suggested it's wrong for the parole board to do that. I mean, in the War Boys case, which we've made reference to, it clearly participated, and the court seemed to regard that as being of value. If it does that, it then potentially, even on the existing law, exposes itself to costs. There's nothing wrong with that. Our concern is that if it puts you to cost by not conceding, which is what it will do, that you should still be able to recover your costs. Why should it make a difference whether or not the costs are incurred because it argues a position, as opposed to it taking the position of merely not agreeing to consent?
Well, I wasn't putting to Mr. Sully the rights and wrongs of the particular case. I was just asking whether you recognise that there is a principle, whatever its parameters are, that you don't make the decision maker liable for costs just because he makes a mistake as it's found in the outcome. And there's no principal basis for doing that.
Well, my Lord, can I say immediately that I just to repeat perhaps something I said a moment ago, we would say that judicial immunity is focused on individual liability of a judge. And if this was a case where there was a risk of personal liability on the part of coroners, risk of personal liability on the part of magistrates, risk of personal liability on the part of parole board members, then we would accept the concerns my Lord is expressing are very real. But that's not the modern world, effectively. And in fact, the Court of Appeal recently, looking at judicial immunity in the context of the Human Rights Act, a case called Mazar, made that point. It's one of the cases we added in the supplementary authorities. The Court of Appeal said effectively, because the Lord Chancellor would be liable for damages, there's no issue of judicial immunity in suing a judge here. It's not about judicial immunity.
I wasn't making a judicial immunity personal argument. I was talking about the function of the person, whether it be a corporate body or an individual. It's just incompatible with their function to make them responsible for the cost of one party on the basis that they're found to have made an error in their decision.
Well, my Lord, I'm not sure why, as a matter of principle, that should be right if one puts it at that high level, because ultimately it goes back to the fairness point I started with and the access to justice point. If they make an error of law, they put the person to the expense, essentially, of correcting that error of law. And why should the person bear those costs? And that's the current situation: is you as an individual potentially bear those costs.
The principle, as I understand, that you're advancing is that if a decision maker makes an error of law and puts the citizen to a cost, then the decision maker, whether a corporate body or whatever, should meet the cost. That would apply presumably equally to statutory appeals as it would to judicial reviews.
Well, my Lord, the difference with statutory appeals, and there is a difference in my submission, is that, of course, in a statutory appeal, there will inevitably be a list, and there will be a respondent to the appeal, and so ultimately somebody else will be responsible. Rightly or wrongly, practice obviously has developed that because the respondent to the appeal can concede the appeal, that the costs essentially will generally be borne by the respondent. So there isn't a problem with a gap. When you're talking about judicial reviews like this,
but what if the respondent is impecunious? What then?
Well, if the respondent is impecunious, then one of the problems with our current system is, of course, it doesn't deal with the person who's impecunious but is a party. I mean, I'm not sure, but I'm not sure, my lord, one can take that example very much further, because of the fact that in those circumstances, at least one has a list and one has another party who one can aim at. They may not be the most desirable party, but one has a party one can aim at. Here, in the context of judicial review, one doesn't necessarily, coroners being the best example, but parole boards would also be part of this. One doesn't necessarily have another party who one can aim at. One is, partly because it is the court that is the respondent.
But in the particular circumstances of this case, where the challenge wasn't to the binding decision of the parole board on release, but was to the parole board's recommendation on transfer.
Yes.
If you waited for the Secretary of State to implement the parole board's recommendation, if so minded, you would have had your deep pocket, as it were, to have as your opponent.
Well, except the problem with there would have been problems with structuring the claim against the Secretary of State and waiting for the Secretary of State's decision. The Secretary of State's policy, as I understand it, we haven't been able to find this in writing, but it does seem, is that if there is a recommendation against transfer, which is what the case is here, that will be followed, essentially. So the Secretary of State would essentially say, my decision is justified because I have the decision of the parole board in my hand to waive. So the real effective decision would always be the decision in this context of the parole board, which is why the parole board was challenged and correctly challenged in our submission.
Well, I wonder about that. If the Secretary of State was faced with a persuasive argument that the recommendation which he was accepting contained a clear error of law, would it be any defense for him to say, well, that's what the parole board said?
Well, he would potentially be able to say, you haven't challenged the parole board. The parole board's decision is a challengeable decision because there are repeated challenges to it. You haven't challenged it. Why should I, when you have a way of challenging it that will allow effectively a court to decide whether or not there was an error of law, why should I revisit that? Because you haven't challenged it.
I think you have my point anyway.
Yes.
I think you could have sued the parole board and the Secretary of State if you'd waited for the Secretary of State's decision, be as it may.
Mr. Southey, just following up on that, if I may, are you suggesting that there would be any practical obstacles to bringing proceedings against the Secretary of State in those circumstances? Might it be said that the substantial decision was that, or what was actually being challenged was the recommendation of the parole board, and therefore you were out of time to bring a challenge against the Secretary of State?
Well, you'd potentially be out of time for the reason, as my lord said. One also, I mean, there's also an issue, which is that obviously liberty is an issue one wants to move on fairly quickly, and the Secretary of State, I don't know how long the Secretary of State would take, but the Secretary of State doesn't necessarily move quickly in this context, and one would potentially want to, one would normally want to, have a lawful parole board decision rapidly, effectively, given what was an issue.
Do you say there'd be any legal obstacles in those circumstances to waiting and bringing proceedings against the Secretary of State when he takes what is ultimately the decision?
Well, if you waited until the Secretary of State, the Secretary of State's decision, and the Secretary of State's decision was over 3 months from the parole board decision, it would be open, I would submit, for the Secretary of State to say, you didn't challenge the parole board decision. It's now not open to you to challenge the parole board decision, and I'm entitled to rely on the parole board decision. I'm not aware of any cases where that has happened, because I'm not aware. The practice, as far as I'm aware, is always that people challenge the parole board decision. Probably.
Does that overlook the fact that it is strictly a recommendation, not a decision by the parole board?
Well, but it's a statutory recommendation. It's made. It's not an. It's made in response to a statutory request from the Secretary of State. It is a quasi-judicial function, to try and use neutral language given the argument about what the function is, but it's a quasi-judicial function, to use the language of Mr. Justice King.
I'm not suggesting it's not reviewable. What I'm seeking to establish is whether it would be a bar to subsequently bringing, whether failure to challenge that would subsequently be a bar to bringing a challenge to the Secretary of State's decision.
Well, my Lord, I think the best way in which I can answer that, trying to be as fair as possible, is that there would be issues. It would be uncertain, and so it would be a risky strategy. And I can't say for definite it would fail, but I can't equally say it would definitely work, because it's just not the way things are done.
Thank you.
My Lord, can I just, I'm conscious of the time, and I'm conscious of the fact I'm a little behind on schedule.
Yeah.
Can I just note for the court that essentially there have, as I've already mentioned, been 3 recent Court of Appeal decisions applying Davis. In chronological order, I think they are Gourlay, that's horrible pronunciation, but which is at Core Authorities tab 3, page 354. Paragraph 30 makes it clear that it regarded itself as bound by Davis. There is the Court of Appeal in this case, which was the second decision. It again obviously regarded itself as bound by Davis. It also, in fact, regarded itself as bound by Gourlay. So one sees how there is a body of authority building up. And then the most recent authority is Fariki, which is Core Authorities tab 2, page 339, the relevant passage, which at para 30 indicates that the court was proceeding on the basis that Davis was binding. Perhaps it's worth noting also, just before moving on, that in relation to Fariki, the court indicated that it understood that the driving force behind Davis was judicial immunity. In my submission, that doesn't actually reflect the reasoning in Davis. Judicial immunity doesn't feature as part of the argument, and for good reason, because of course Davis leaves open the possibility that doesn't say there's any reason why coroners can't assist the court by attending and making submissions on the law. It just says if you do that, you're potentially at risk of costs. So it's not suggesting there's anything objectionable, it's a matter of principle in that, or that there's anything objectionable in awarding costs if that occurs. It just says essentially that because of the need effectively to compensate the individual, in those circumstances, you become liable for costs. That probably is as good a place to break.
Yeah.
I will, over lunch, try and take further instructions, but it may well be that we want to put something in writing as well.
Yes, well, I appreciate you are short of time.
Yeah, yes. No, I'm very conscious of the fact I'm short of time, so I will try and speed through. So a couple of things after lunch. Thank you.
Yes. Thank you very much indeed. We'll adjourn now and resume at 2 o'clock.
Thank you.